So I don't want to keep people waiting. So let's see here. So we have a few people here who are my, I've asked a few people to join us today that can help us answer some questions that some of you might have. I have a business attorney that's joining us. I have some other professionals that are here. So if there's a question that I can't answer, I'm hoping that one of them will actually help us answer the question. There's a lot going on, whether it's on the business front, whether it's on the healthcare front, and I want to make sure that we kind of trump some of these terrible pieces of information that are kind of fluttering around. So I'm going to start with a question that I've received a handful of questions from Instagram, and I have a few from Facebook Messenger that I'm going to answer, but there's a few questions that I received from Instagram that I want to answer that I think are related to and in the forefront of a lot of people's minds. So the number one question, 3 people asked me this question, is younger people are scared that if something happens to them, whether it's through Corona or some other whatever negative thing that happens in their life and they pass away, there's this notion or this idea or thought, they think that everything is going to be taken from them by the state of California. They think that the government is going to step in and take the property that they own, the bank accounts that they own, if they don't do any planning. That is not true, okay? If you haven't done any planning, the state isn't going to take it all away from your family members. There are intestacy laws that control. So if you have done nothing, you're sitting in your living room right now, you're like, I haven't done a will, I haven't done a trust, I haven't done any paperwork whatsoever, that's okay. You don't have to panic because the state of California is not going to swoop in and take everything you own if something happens to you. There are probate codes in place that are going to allow whatever you own to go to your family members. So the state of California will not take, we call that the legal concept where the state actually takes what you own is called escheating to the state, for my lawyers on the chat here on Instagram. So escheating is what happens when somebody passes away and they had no family members whatsoever. So they had no one in their lineage, and therefore the accounts or the assets were just left hanging in thin air, and the state comes in and swoops it up and they deposit it into the unclaimed registry that the state controller has. So if you think you have a distant aunt or uncle that may have had something that the state had, I would actually urge all of you to go and Google state controller and type in the name and last name, and it'll actually tell you if there's any unclaimed assets. So it doesn't necessarily mean that it goes to the state automatically. The state would actually only take it if there's nobody in your family to claim through intestacy laws, meaning, you know, absolutely no children, no parents, no brothers or sisters, no second cousin once removed. And for most people, they have someone in their life, they have some blood relative that can take. So we have a lot more people who joined us. Hi, Alan, how are you? He's on Facebook. Thank you for joining us. If you guys have questions, just type them in and I'll do my best to catch them and answer. So we were talking about intestacy laws and how some people have this terrible fear that if something happens to them and they haven't done anything, the state of California is going to step in and like take things from their kids. And I was just reiterating that that is not true. If you have done no estate planning whatsoever, that's okay. The state of California is not going to take it. It's just a matter of it going to your next in line kin, and the process that it goes to them through is something that we trust attorneys don't like. So that's the entire purpose or the goal behind estate planning, right? We want to create an estate plan, and you want to create an estate plan so that it doesn't channel through the court system, because we live in a very, very expensive state. So imagine the cost of housing and in California compared to other states, and equate that to the cost of probating a case. So on average, like if you have $1 million home, let's say in like Pasadena, and you have a $900,000 mortgage on it, you have liabilities on it, the probate system doesn't care. They will charge based on that 1 million. So your probate attorney's fees will be like somewhere around $20,000 to $25,000, depending on the value of the asset. So it's very, very expensive. In contrast, you can do pre-planning for like a couple of $1,000 and just rest easy, right? So, hi, Mike. How are you on Facebook? Thanks for joining us. Natella has a question. How are the cases that are in the middle of being probated affected by the current court closure? Awesome question. So the probate court is not only for people that pass away, but the probate system actually does a lot of great work for individuals that are really sick and they can't care for themselves. And so they have a conservator appointed. So there are some temporary workings that the probate system is currently still functioning through. So I know that a lot of the civil friends that we have are kind of at a standstill with their cases. Probate is a little bit more lenient. We're somewhat still functioning. There's still some ex partes that are happening. There's still some emergency actions that need to be taken on behalf of people that are elderly, that are sick, that can't function, that cannot take care of themselves or their finances, and someone has to step in. And so the probate system is also has jurisdiction to handle those types of cases. So we're not as badly affected as some of the civil attorneys out there who are, if for those of you that don't know, the courts are actually closed pretty much, and trials have been delayed based on this stay-at-home order. And so it's actually causing a lot of disruption in the legal industry because cases are not moving along, right, if they're in litigation. And so a lot of friends that have civil actions pending are actually at a standstill. You can't really work your case up. You can't file a motion. You can't really threaten the other side with filing a motion because you can't actually file the motion. So it's causing a lot of disruption. So yeah, that's, on my end, it's affected our work, obviously, because everyone's very hesitant as far as what they're doing. But as of last week, more and more people, I think, are sitting at home and realizing, wow, the unexpected that we didn't think would happen has happened, and I'm not prepared for it. And I think that's the shock that a lot of people are feeling, like the same way that you didn't have enough toilet paper in the house and you might have rushed out and bought it is the kind of the feeling that people are feeling with respect to their estate planning documents. They're realizing that they're not, they don't have everything prepared. They don't have a plan of action prepared. So it's causing a lot of stress. And one of the questions that I keep getting asked is this question about, if I die, does the state take it all and my kid gets nothing? And I actually got asked that question today by a young single mother. And I had to just put everything aside for a minute and calm her down and say, no, it's actually not going to go that way. So that's not something you should be worried about. It's going to end up with your kid. It's just the process that it goes through is going to be pretty bad. And about, 20 to 30,000 of the money that would have gone to your kid is going to be spent on attorney's fees and court expenses, right? Which is totally not necessary. You could just create a simple estate plan and have it go according to your wishes without having the court involved, according to what you want, what you're kind of dreaming up for your kids. So that's one of the number one myths that I've been hearing a lot more lately. We usually hear this a lot, but lately it's been a lot of, for some reason, this fear is coming out even more. So I wanted to address that. And then I also wanted to talk to you about this universal DNR news that's going around. So we made a video on this and it's published on our blog. There were talks and news reports. Tina, I see your question. I'll answer you in a minute. Actually, let me answer Tina's question before I go on to this hot topic of universal DNR, because I think we're going to get stuck on that for a little bit. What's the first step to getting an estate started? So it's really, really simple. I think the first step for everyone is finding an attorney that they like, right? So do your research, find an attorney that you enjoy working with. With an estate plan, it's a long-lasting relationship, meaning you're in a long-term relationship with your attorney. So I always say the first interaction between me and a client is an interview. Do I like you? Do you like me? Do we want to enter into this long-term relationship together? And then it's usually very easy steps. So for my office, we do a free consultation that's usually about 30 minutes. And before this Corona, we would do the consultations either in office or over the phone. But because of Corona, we're doing them exclusively telephonic consultations. And then at that consultation, we'll give you an idea of, what it's going to cost based on asking you some questions and figuring out what type of planning or how complex your planning might be, depending on what assets you have and what family structure you have. And then once you're ready to actually get the ball rolling, that's when we would send you a simple questionnaire. You would fill it out and you would come back and we would actually sit there, the two of us together, and we would go through an entire hour to a 2-hour session of planning out different hypothetical situations and how you would want everyone to react to it. So it's basically me throwing out a question of, what would you do if this, this, and this? And you answering the question of, I wouldn't want my kids to do that. And based on that conversation, I go back into my office and I take about a week to 2 weeks to write up everything and send it to you. And once you review it and read it and approve it, you basically come back into the office to sign. So Alan Taylor, a local realtor, is asking a question. Let's see. Alan wants to know, I have a probate sale requiring court confirmation, confirming that no court confirmation hearings are taking place, and also if an ex parte is filed to go full authority, how long would that take? That's a really good question. I would have to go back to the recent emails that have been going back and forth, Alan, between me and my study group members to figure out what the best way of addressing that is. Shoot me an email. Because I know I'm going to forget. Shoot me an email and I'll see if I could get some more information. I think if there's exigent circumstances, there might be a way to like squeeze it along, but send me an email, shoot me an email, and let's figure out how to get that done. So I wanted to talk to you guys about the universal, this universal DNR. So there's news reports going around that hospitals are considering, they're just considering, implementing a universal do not resuscitate order, meaning that normally, let's take a step back. Normally, if I go into the hospital and I am very, very sick and something happens to me physically and I am mentally gone and I cannot make decisions for myself, what's going to end up happening is that physician and that hospital is going to look at my power of attorney for health to decide, to figure out who's in charge. So for example, my husband would be in charge of making medical decisions. So they would turn to my husband and they would say, what do you want? Do you want us to pull the plug on her or not, right? To put it bluntly. So he would be responsible for making that decision. There might be something in my power of attorney for health that says, I want the plug pulled if I'm in a vegetative state or if I'm this, this, and this. So that's a personal choice for the person that is entering the hospital. The talk that is going around universal DNR is the concern for physicians and the concern for the hospital is that when a COVID patient is in ICU and they go into cardiac arrest or they stop breathing, the problem arises because it's a huge problem for them because they have to suit up in protective gear and like a minimum of 8 people rush into the room and do everything possible to keep this person alive, right? It's a code blue situation. During a code blue situation, anything and everything goes, right? So they're inserting, not to be graphic, but they're doing everything they can to keep this patient alive, which creates a lot of liquid particles and things that are spewing out everywhere, blood, everything. And that's creating a dangerous environment for these doctors and nurses. So the fear is that they are actually spending more supplies on a code blue patient and that they are also risking themselves if they're not properly geared up and they rush in to save the person's life. And so the talk is that, if it's an ICU patient, doing a universal code blue for the safety of the hospital staff, for the insurance of keeping medical supplies up and running. There's only a certain number of machinery that can be used in the ICU. So if they're, taking it away and whatnot. So these are just bioethicists analyzing the situation, guys. There is no law in California that says that physicians and doctors can do this. They cannot do this. This is just a bunch of bioethicists whose job it is to analyze these types of pandemics and scenarios and to give hospitals advice on safety. And so it's something that people are considering, but I want the takeaway to be that no one has implemented it at all. You still have the right to make medical decisions for yourself. If you don't have a power of attorney for health, the default in the law is it basically goes spouse, children, and then parents, siblings. So it basically trickles down your family tree. But if you don't have a power of attorney, I would highly recommend you get one. There's a statutory power of attorney form that's available online if you don't want to go through an attorney. And you can read it. And if you like what it says, you can kind of sign that and have that in place until you can do one with an attorney that's a little bit more specific to you and your wishes. We have a link to that power of attorney form on our website. We have bazikyanlaw.com/COVID. We have a list of COVID resources, and one of those resources is a power of attorney for healthcare, the statutory form, as well as a power of attorney for finance. So we don't want a scenario where if you're in the hospital and you can't make medical decisions, that's one issue. The secondary issue is if you're in the hospital, you're fine, you're just in the hospital and you can't pay your bills and you can't call and talk to people regarding your finances. You want to make sure that someone in your life that you trust has a power of attorney and that they could do it for you. So the power of attorney for finance covers everything financial related, and the power of attorney for health covers healthcare related decisions. And it's a really good idea. You don't need to be super wealthy. You don't even need to be, you can, it doesn't matter who you are. Those two documents are good to have in place. So we have a new question on Facebook. No, on Instagram. Okay, I don't know what that means. IG. Answer the question. Do you know what it was? Because I think I skipped it.
Not questions, just 2 comments.
Got it. So do you guys have any questions for me so far? I've just been blabbling on and on about this universal DNR. So if you guys have questions, let me know. How are you guys feeling about this universal DNR? Do you think that there's going to be some sort of law passed? I'm curious to hear what the public thinks. If there's actually something that's going to go into temporary effect, that's going to actually allow physicians to do it. Oh, good. I'm glad some people were actually, yes, I'm Valentine. You answered the question I was typing. Yes. So this universal DNR has caused like a frenzy. I've gotten so many comments on Facebook. I did a video hoping that it would help people understand it and calm them down, because there's a lot of companies out there that are just spewing out information and scaring people into going and paying a law office to do a power of attorney form, which doesn't sit well with me. Do those power of attorneys have to be separate, or can they be consolidated in one document? So the statutory forms are actually 2 separate documents. They're not consolidated into one form. So the health is separate, the financial is separate, and they shouldn't be consolidated in any scenario. They're addressed to 2 different institutions. They likely have a 2 different set of people in charge. Most people that have someone in charge of their healthcare do not have that same person in charge of finances. It's kind of different personalities in their lives. So it should be 2 separate documents. So the forms that are on our COVID resources page are statutory forms, meaning they are written in the law. So the probate code says this is a statutory financial power of attorney for health form. You can use it. And I haven't obviously used one recently, but it should be a kind of check the box, fill in your name type of situation where you can just do it yourself. What is this comment? I think people misunderstood the message you wanted to send in that video. I think so too. I actually had a few comments that definitely misunderstood it from medical professionals. It's funny because I had a group of medical professionals who were direct messaging me on Instagram and saying, people who watched the entire thing, saying, thank you. I'm so glad that someone's like putting this information out there and letting people know that it's not real. And then I had people that were just watching like 5 seconds of the video and commenting. And I can tell that they didn't understand it because they actually didn't read the entire or watch the entire thing. So for the most part, it was my goal was to make sure that people understand if you go into the hospital, some hospitals actually have their own healthcare DNR orders that they'll make you sign, or they'll ask you if you want to sign. And if they don't, the law will always, always, always fall back on what the probate code says. And the probate code says that if I am married, my husband will be in charge of medical decisions for me. So let's see here. Sosi says, if it were to be passed, would there be a way around it? Don't know if that makes sense. That makes total sense. So the question is, what I said is, this is the only way that people can do this, hospitals and physicians can do this, is if there's like a temporary law in place that gives them the permission to do it. And so Sosi is asking that if it was passed, would there be some way around it? I think definitely if they put into effect some sort of law that says a hospital can decide for you, there's gotta, these legislature, the individuals that write these laws are lawyers at the end of the day. There's gonna be something in the fine print that says, except or unless you have already executed a power of attorney form which states the opposite. This is why it's more important, even more so important, to actually do your own so that everyone around you knows your wishes and they're not falling back on like what is written in the law or what the current scenario is or what, someone in your life is saying that you're not very close to, but that just so happens to be, the next in line. So Sosi, did that answer your question? I think that's what you were asking. You're giving me little hearts on Instagram. I'm assuming that's conversational for yes. Yes. That's young millennial speak for yes. Thank you very much. So if you guys have any questions, please let me know. I think this is a really good time to update your documents. If you don't even know where your estate planning documents are, it's a really good time to look for them, pull them out, dust them off, make a copy of that power of attorney for healthcare, put it aside in case you need to go to the doctor for whatever reason. You'll have it on hand. You won't be panicking. I think in times of uncertainty, you cannot control what's going on outside your home. You can't control the virus. You can't control the rules that are being put in place. But you can control your emotions and your mind, right? You can implement or you can comfort yourself by making sure that you have a plan of action. So don't control things that are out of your control. Try to put a plan in place, do things that you can do. And one of the things you can do is making sure that you have a solid plan in place, whether or not COVID is around or not. I think, for most people, you need those in place. Do you handle POAs nationwide or just California? Oh, that's a really good question. So I'm licensed in California. So I personally, if I were to draft a power of attorney for health that's specific to one person, it would be for California. And the same thing for the finance. But power of attorney documents are specific to the state. There are state laws that control, the probate laws are state specific. There is no federal law that covers death. Each state has the power to make their own laws when it comes to what happens when people die and when people are very sick and they can't do things for themselves. So power of attorney documents are very specific to each state. So I would recommend that you kind of research what the laws are in the state that you're living in. So if you're a resident of Arizona, you need to research and see what power of attorney documents are in place there that you can kind of get going for yourself. Okay, so one of the questions that I got was a question from Instagram earlier today. Will student loans be discharged at death? This is a really good question. So basically, it's an individual who went to grad school or undergrad, racked up student loans, and now they're doing fine, and they have maybe a little bit of an estate, they own a house, they have some bank accounts, whatnot. And the fear is that when they die, those student loans are going to be owing and due, and their family members, their kids, are going to have to pay back their student loans. It depends on the student loans. So I'm going to give a very lawyerly it depends answer, but it really does. So if you have federal student loans, they are discharged at death. If you have private student loans, they are not discharged at death, possibly. It depends on what your loan agreement says. So I hope that answered the question of whoever it was that asked. I don't have their name in front of me right now, but federal student loans are discharged. Non-federal student loans are not discharged, likely, but it really does depend on what it says. And also, I want to make a note for the parents out there that actually signed a guarantee for a student loan. So it depends on, so be very careful of that as well. What about other debts? Other debts are not dischargeable. So just because you pass away, it doesn't mean that your credit card debt and your, your other monies that you were owing to someone else just disappear. So when we talked about the probate system earlier, the reason the California probate system takes so long, so the reason it takes so long when somebody passes away to get that house to the new family member's name is because our system, our probate system, has a 4-month creditor claim period. So when you file for a probate for 4 months, you cannot transfer the asset to the children or to the husband or to the wife, because for 4 months, the court wants you to sit there, give notice to every single known credit card company and creditor that the person had. And we basically sit there and we wait and we see who comes forward. And if the credit card company comes forward and says, yep, yeah, Chase over here, there was a $2,000 bill, can you please pay that? What they end up doing is filing what's called a creditor's claim in the probate. And the judge will force you to pay that before they'll allow you to discharge it if it's a valid debt. So I hope that helped. Facebook question. Okay. Do you handle, well, we did that one, Alan. And then the universal DNR you are talking about was California or nationwide? It was actually in, I think it was Pennsylvania. It was on the East Coast somewhere where the universal DNR was being considered by the bioethicists, and some of the hospitals were actually looking at that report and trying to analyze and figure out, what to do and how to move forward. So the reports that I read about the universal do not resuscitate order were not in California. But of course, along with those, I saw posts by, unfortunately, attorneys and other companies that are in the business of creating forms for people for a fee, advertising and like preying on people's fears, like, get a POA in place, get a power of attorney in place, because if you don't, the hospital's going to decide for you. That's not going to happen, guys. Like, don't listen to those people. So let me see. What about other debts? We answered that question. Why? Oh, got it. Okay. So we have a question. Am I understanding that question right? Did I see it right?
Yes.
Auto-generated?
No, just like the question was for why wouldn't I go with the form generation?
Form generation. Oh, so many reasons why you wouldn't do like a LegalZoom or some other type of company. Your estate plan is very unique to your family structure and your assets. So I don't recommend form fillable programs. And I say that making more money off of fixing problems that come from that. So I actually make more money fixing problems that are created when someone goes out and does their estate plan on the cheap and then they pass away. The family comes to me and hires me to go to court and fix it. So I don't mind. I actually earn more of a living doing it that way when people decide to take a shortcut. But I really want people to actually do it the right way and do it correctly, because the difference between a couple of $100 or a couple of $1,000s, whatever it is now, is actually going to cost your kids hundreds of thousands of dollars in bad tax planning in the future. And that's the number one or like top 3 problems that I see is bad planning by a previous non-specialist attorney creates some tax consequences that are in the hundreds of thousands for the kids. And I have to be there, sitting there and telling the kids, I'm really sorry, but you know, it could have been easily done correctly, but it wasn't because your mom wanted to save $1,200. And so now I'm charging you $450 an hour to go fix this problem. We have another question. I guess to be more specific, as my dad's trustee, do I get to pay his debts? Yes. If so, so what I answered for you was the creditor claim period in probate. So for a trust, it's a little bit different. So the creditor claim period is 4 months for probates for cases that are probated, meaning somebody has a will and they die, it goes to court, or somebody doesn't have anything done and it goes to court. So that's a 4-month creditor claim period for probate. And believe me, guys, they come out of the woodworks. I have had creditor claims on my cases for like $300, and they've gone through the trouble of paying and hiring attorneys that file the paperwork. The attorney probably cost more than the $400 debt, but they come after it. So there are some banks and some companies, some credit card companies that will actually, as a matter of principle, will come after you. So hi, Christina. Hi, Mary. We have a few people that joined us. Hi, Ani. So for trust, it's different, right? So yes, you are responsible to pay the debt. If you are the trustee, you have a fiduciary obligation to the beneficiaries as well as to creditors. So if there is a known debt that you are aware of after your father passes away, you have to pay that debt. There are procedures which are more favorable to trusts than to probate, where we can shorten that time period, which is actually it's a nicer way. That's another benefit of doing a trust. So for a trust, it's a little bit different, but you are still, at the end of the day, my answer is still yes, you are still responsible for paying debts of the estate and the trust. Okay. So let me know if you guys have any other questions. So let's see here. Tax questions. I love tax questions. I always say I consider myself like more of a tax attorney than anything else. So the question is, how does an attorney, like how do taxes come into all of this, right? We're planning for death. And we have another question from Christine. I'll answer your question in a second. So when I do the estate plan for clients, my number one goal is to save money from going out of the pot, right? I'm creating a basket, I'm putting everything in this basket, and my number one purpose in life when I'm hired by that client is to keep everything in that basket and to safeguard it. I don't want that basket to be transferred to the wife or the husband when one of them dies, and for them to be in a scenario where I have to tell them, oh, you know what, if you sell your house, there's going to be a capital gains bill because I did it incorrectly. Or when it goes to the kids, I don't want, from the kids' perspective, for them to be limited in what they do with it because they're concerned about estate taxes, capital gains taxes, gift taxes, property taxes. So we have a rainbow of taxes that I'm dealing with when I'm doing estate planning. And behind the scenes, most of my clients don't know this, behind the scenes, I'm like, tick, 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 tick. I want to make sure that from the kids' perspective, we've planned it correctly, or the beneficiary's perspective, from the surviving spouse's perspective, we've done everything correctly, because I consider myself more of a tax attorney, tax estate planning attorney than anything else. So I think that's very important. And I see that all the time where a client will come in and say, my husband died, I want to sell this property that we own together, it's our house, and I want to move into a smaller house. And we look through everything, the trust that they had, and I have to say, I'm so sorry, if you sell that house, you're going to have a huge capital gains tax on your hands. And most of it is going to go to the IRS because, the attorney that you hired to create this trust 15 years ago did this one little document incorrectly, and there's no way for you to correct it now. So those are kind of the conversations that I'm having when it's an incorrectly created estate plan, or one that doesn't take into consideration future taxes, or one that's done through like a doc preparing service. Okay, so let's go back to some of these questions. Should you compensate your trustee or executors? It's not a matter of should you. They are entitled to a reasonable compensation in California. So a reasonable compensation, most of the time, first of all, a trust will describe what the compensation is. But if it doesn't, the default is going to be reasonable compensation. And that's usually about 1% or so of the assets of the trust. But there are different theories on that. There's different factors that we consider. So if the trustee did a lot of work, a lot of like micromanagement and cleanup and like organization and had to prep, for example, a property for sale, they're going to be entitled to a little bit more compensation. What I find is that most people that are family members or friends named as trustees or executors don't take their trustee fee, they waive it. I always ask in the beginning of a trust administration or a probate, hey, are you going to take your trustee or executor fee? And everyone's like, no, it was my beloved brother who died, and I'm not going to take a fee from their children or whatnot. And then I always ask again at the end, because they've gone through an entire year of very, very hard work. And I want to make sure that that answer stays. And a lot of the time people switch because it's a lot of work that these trustees and executors do. If you die without a will or a trust and it goes through probate, whoever the person is that's probating the estate gets a statutory fee, meaning their fee is written in the law and it's the same as what the attorney gets. So on that $1 million house, for example, the attorney would get like 20 grand and the administrator of your estate would get 20 grand off the top. So that's something to consider. And they're entitled to that. So let's see here. Let's look at some other questions. I hope I answered your question, Christina. So his ex-wife opened a credit card. Oh, we're getting into the juicy details, huh? Okay, his ex-wife opened a credit card and maxed it at 30K, still paying it off. Both of their names are on the credit card. She's never worked in her life, so he's still supporting her financially. So I think it depends on the type of debt, right? But yeah, it sounds like she may be responsible as a surviving spouse. There's a lot of community property laws for debt due at death. And so I would definitely look at the type of debt it is, who it benefited, and who remains on there. So if we have any other questions, let's see here. So I'm going to go to my next question that I got earlier today that I received. The question was, what do you recommend for people who are heavily invested in real estate and whose basically their job is to flip homes, right? They buy homes, they renovate them, and then they sell them. And then after this question, I don't think we have any more questions, so I think we're gonna like wrap it up. So for people who are heavily invested in real estate, the number one takeaway is that if the house or property is in your name and just your name and you die, it's gonna go to probate. So when it goes to probate, until the people in your life that would take it to probate, so let's say your husband or wife, until that person takes it to probate and gets proper authority to act on your behalf, which takes a couple of months, your family can't do anything with that property. They can't sell it, they can't mortgage it. The mortgage company won't even talk to them until they have official letters from the probate court that say, hey, this person's in charge. So the number one thing would be to make sure that you have a trust in place and that you have planned for death. The second thing would be to make sure that you're doing some asset protection planning, because you're obviously in the business of flipping and you're obviously hiring a lot of contractors and workers to come and work on the property. So your liability is kind of like through the roof, and it might be a good idea to have a lot of umbrella insurance. I know we have a couple of insurance agents in the audience watching today, but it would be a really good idea to consider some form of asset protection to safeguard the thing that you've worked so hard to buy and flip, to make sure that if there is a lawsuit, you have some level of protection. We have a question. What do you recommend to parents with teenagers and young adults that drive? So if in case they get into trouble, your property is not jeopardized. Oh, so much, but you're not going to like any of my recommendations, Ani. I would recommend you get that car and you put it into their name. You should not be the owner of that vehicle. There's limitations on owner's liability in California. I have a civil trial attorney sitting next to me, so I'm going to turn to him for confirmation on this. But there's limitations. He's giving me the thumbs up, so I'm giving good advice. There's limitations on how much they can sue the owner of the car for. 1530, is that what it is? Yeah. My husband's a personal injury trial attorney, so he's telling me that you can sue for a max of 1530. So if you have your son's driving a car, he causes an accident, he kills somebody, they sue, they're going to sue your insurance company, right? They're going to sue you, and they're going to sue your son as the driver. So he's telling me that the liability for the owner of the car is capped, meaning maxed out at $15,000 per person that's injured and $30,000 per accident.
One exception.
Negligent
entrustment.
Exception is if you have negligently entrusted your child with that vehicle, like your kid was just an irresponsible driver, had constantly been in accidents, was drinking and left the house and you knew that, then that's an exception to that rule that I set. But my recommendation is going to be get that car into their name, get them insured on their own, basically cut the umbilical cord and cut the ties with you. You should not be the owner of that car. Get them a car in their own name, have them go out and get insurance. Yes, I know it's going to be a very expensive way of doing it because obviously premiums are going to be really high, but in your mind, I want you to think of that high premium as a little bit of insurance for yourself to be able to sleep at night. So that's something that I would recommend if you have young kids that are driving. And it's also a good idea to obviously have everything. If you have investment property, it's also a good idea to do some asset protection planning, because that would also give you a lot more protection if there was a different type of lawsuit that kind of flowed over into you that they could get you for. So Julie, we have a great workers' comp attorney with us today. So let's see, other questions. And you should not name them on the deed as joint tenants. Ah, yes, the number one question. We see this a lot where parents will put their like 20-something-year-old as a co-owner on their house. And it's like what I call do-it-yourself estate planning. Instead of going out and doing a trust, they're like, oh, I'll just add you to title. And then when I'm gone, it'll just go to you because you're the joint tenant. Very bad idea. There are a lot of negative tax implications of doing that. Yes, you avoid probate because at your death, it goes to the joint tenant, the kid that's alive. But when they turn around to sell that property, they're going to have a huge capital gains bill on their hands. So that's something that I don't recommend. Second, it's not safe. Why would you put your kid on your house? If your kid's involved in a lawsuit, whether it's a car accident or he punches somebody, you're going to be sued as a co-owner. They're going to be able to come after everything that he owns, which is the house that you're living in that he's entitled to. So not a good idea. Let's see here. I've seen the blog post for this, but for any young adults watching, what are some documents you suggest we have? So I think for anyone over the age of 18, whether you have assets or not, you should always have a digital power of attorney, a healthcare power of attorney, and your financial power of attorney. So we have the debt fairy who says also a bad idea when bankruptcy or debt settlement comes into play. Yes, definitely. Am I reading these comments correctly? Oh my goodness, I scrolled up. So yeah, it's definitely bad when there's bankruptcy or debt settlement that comes into play. So I hope those were all the questions I had. Let me just make sure I'm not missing any that were asked today. So we have one here. What is your recommendation for minor children that would inherit a trust? Can we include life insurance policy in the trust? And how does the guardian access the funds to support the child? Awesome question. You would definitely include that life insurance in the trust if you are wanting it for the purpose of taking care of your kid. There's so many things that you can do for minor children. Am I frozen? Okay, I think what Instagram's going to do is, by the way, kick me out because we're reaching an hour, so I'm trying to wrap it up so that we could save this video. But my recommendation for people with young children, if you have kids under the age of 18 and you don't have a house, you don't have a big bank account, but you do have a life insurance policy, guess what? When that life insurance policy wants to be paid out because you've died, they're not going to pay until that kid has a guardianship case opened at the probate court, and they're going to pay directly into that case. And that your child is going to access that money at 18. So you don't want that. So if you have nothing in your life, but you have a life insurance policy and a kid under the age of 18, you need a trust in place. When you get that trust in place, you can do whatever you want. You can give it to them however you want. You could put whatever access limitations you want on them. Anything that is not against public policy, you can do. So you can say, you know what, Tommy, I'm going to give you this $1 million life insurance policy. It's going to pour into my trust. And when you're 30 years old, that's when you get this money. And until you're 30 years old, you can use it for college. You could use it for anything healthcare related. You can use it to buy yourself a car. So there's different rules that you can put in place to allow them to move and shake. And you would also appoint someone to be in charge for your child until a certain age. So it wouldn't necessarily be your kid when he reaches 18. You can put a trusted friend or a brother or sister and say, you are in charge. You make sure that this money is safe and you take care of it until Tommy reaches 30 and then give it to him at that point. So I hope I answered the question. Can we include life insurance? I answered that. How does the guardian access funds to support the child? So there's a relationship between the guardian and the trustee. So the trust has somebody called a trustee. Your kid, every day, day-to-day decisions are made by somebody who is called the guardian. For some people, they're lucky. These are the lucky humans. They have one person in their life that's both financially savvy and a really great caretaker. So they can name that one person in both those roles, which means the guardian can have access as trustee to the money. Some people don't have that. They have a separate person who's going to take care of their kid, and then they have someone else who's going to take care of the finances. At which point, up until the age of 18, the guardian kind of goes to the trustee and says, hey, trustee, I need $20,000 for this summer program that I want my kid to be involved in. I want the kid to be involved in. And the trustee says, you know what, we have money, but we don't have a lot of money and we should really save that for college. I don't think we can send him to that program. So those are the kind of decisions that the trustee would make, but the guardian kind of has a request right, if that makes any sense. So I don't know if I answered your question. If I did, maybe a thumbs up. But there's the beauty of the trust is that, you know, this is your basket. You can weave it in whatever shape, form, texture you want. And your basket and my basket would look different, right? They should look different. And if they don't, then we have a problem. Thank you. That was from Mariana. Okay, good. I'm glad I answered your question. Would you recommend the trustees and the guardians to be the same person? I think I answered that. If you're lucky enough to have someone who's a very nurturing personality and also super financially savvy, why not? Some people like the idea of having a different set of people so they could do like a checks and balances and check in on each other. It just depends on, honestly, your family situation and the trust level between you and your trustee and you and your guardian, and the type of personalities that you have around you. So I don't know do you have to redo your trust when you are filing a divorce? Yes. Oh, this is a good one. So when you file for a divorce, you actually can't redo it. There's a restriction that gets put into place. Anytime you file a divorce, on the back of that divorce form that you sign, there's an automatic stay that goes into place, meaning everything gets frozen. You're agreeing that you're not going to transfer anything until the court hashes out your divorce, right? So you're agreeing you're not going to transfer anything. So technically you can't transfer assets, but you should definitely prepare, you should definitely do some estate planning. There's still things that we can do to make sure that if during that divorce you die, it doesn't go to your soon-to-be ex-husband. Or if during that divorce you're in the hospital, your ex-husband doesn't show up and say, I get to pull the plug now. So there's things that we can do short of transferring assets. And there's always exceptions to that. You know, if it's a fairly straightforward, good divorce relationship between the attorneys, you can always request approval from the other side to go ahead and transfer. I think, Tina, what your question was is, should you update your documents after you have finalized your divorce? And that question, the answer to that is absolutely. So if your legal status has changed, and this is to all of my peeps out there, you know who you are. If you were married and you went and filed for a divorce, but you are still technically together, you need to update your documents. Married, I have a video on this called unmarried couples who are not legally together. You need to be very careful how you structure your estate plan, and you need to be very careful the rights that you have with respect to each other. So if you're not legally married and your husband's in the ICU, you're not going to be able to go in and make medical decisions. I mean, never mind, I won't say what I was about to say. It would be giving out incorrect. So yeah, so for I hope that answered your question. So if your legal status has changed, you should update your documents. If you've had children, like Kobe, his fourth child was not included in his estate plan, you should definitely update your documents. When you have kids that you didn't have before, I think this is a really good time to kind of review everything and see if everything is up to par with what you want. We have a question on Facebook. How much do you charge to do a trust? So I don't have any flat fees at our office. Our fees, the way that we work, is based on the needs of our clients. So it depends on a number of factors, some of which are the type of assets that we're dealing with and the type of family structuring or the type of trust that we're creating. So for most couples, there's some variations in types of plans that we can put into place, different rights that they give each other, different powers, different tax planning that we do. So I would say give us a call. We do free consultations, so you're not losing anything by calling our office. You'll give me some information and I'll let you know what the exact price is. And we do flat fees, so at the very least, it'll be one fee that you'll get charged. Is business partnership interest included in family trust? Yes, it should be. All of your interest, anything that you want to go to your kids should be in this basket. So if you have something that's not in this basket, it's going to go to court and it's going to go through probate and testacies. Oh, we have Momfident woman. Yes, Edith, you can ask me anything you want. And I'll advertise my beautiful O'Connor Ginsburg Sotomayor Kagan cup, my mug. What's your question, Edith? This is on Instagram for everyone. And I think Instagram is going to kick us off, if I'm not mistaken. In how many minutes?
In like 3-4 minutes.
3-4 minutes. Instagram is going to kick us off, guys. So I'll have to come back on to answer more questions. If you have more questions. If you guys don't have any more questions, we can call it a night.
Yes.
Are you wearing PJ bottoms? You're so funny. You'll never know. Thank you so much. Very informative. So yeah, I think we're gonna, hi Magda, how are you? So the takeaway is review your documents, make sure everything is what you want. And then if you have a power of attorney for healthcare, just, copy it and just leave it around the house. And that's pretty much it. You guys are welcome. I'm glad you guys are finding the information helpful. If you guys want more of this, or if you have other questions that you want to ask privately, go ahead and call our office or message us, and we will make sure that we answer your questions, especially if it's a private question that you want answered privately and not for everyone to know. I've been doing this for about 10 years now. I've been exclusively practicing estate planning, trust, and probate administration. And I am happy to announce that I'm actually a specialist in the areas of estate planning, which is an additional mini bar exam that's taken by the attorneys in this practice area. And so I'm happy to announce that I'm also a certified specialist in estate planning. So when is the next round? If you guys have more questions, we'll do another one. And I'll try to get people that can provide some information for you guys, especially for the tax laws that just came out. I think that's going to be pretty important for businesses and people to know about. Yes, we do free consultations. We do free 30-minute conversations. So please give our office a call and we'll be happy to answer any questions that you might have. Okay, everyone, it was really nice. Thank you so much for joining, and thank you for all of the amazing questions. You guys asked some really good questions. Have a wonderful evening and stay safe. Bye.